Welcome to EUPrivacyForAll Session39 on GDPR, Article 43, Certification Bodies. Article 39A was finally renumbered 43 on certification bodies. Basically, the certification bodies which have an appropriate level of expertise in relation to data protection shall issue and renew certification, and member states shall ensure that those certifications bodies are accredited by either the supervisory authority which is competent or the national accreditation body named in accordance with the regulation of 2008. Those certification bodies shall be accredited in accordance with paragraph 1 only where they have demonstrated their independence and expertise, undertaken to respect the criteria approved by the supervisory authority nationally or by the European Data Protection Board at EU level, establish procedures for the issuing, periodic review and withdrawal of data protection certification seals and marks, establish procedures and structures to handle complaints about infringements of the certification, demonstrate to the satisfaction of the competent supervisory authority that their tasks and duties do not result in a conflict of interests. Finally, the accreditation of certification bodies shall take place on the basis of criteria approved by supervisory authorities nationally or the board at EU level. The certification bodies shall be responsible for the certification without prejudice to the responsibility of the controller or processor for compliance with the GDPR. This accreditation shall be issued for a maximum period of 5 years, and it can be renewed. The certification bodies shall provide the competent supervisory authorities with the reasons for granting or withdrawing the requested certification. Moreover, the requirements referred to and the criteria set nationally by supervisory authorities or at EU level by EDPB shall be made public by the supervisory authorities in an easily accessible form. The board shall collate all certification mechanisms and data protection seals in a register and make such a register publicly available. The competent supervisory authority or the national accreditation body will have to revoke the accreditation it granted to a certification body whenever the conditions for the accreditation are not or no longer met. Finally, the Commission shall be empowered to adopt delegated acts, and it may adopt implementing acts laying down technical standards. In different provisions, the GDPR makes clear that certification is a key tool to demonstrate compliance and to enhance transparency. For instance, in Recital 100, it is seen as allowing data subjects to quickly assess the level of data protection of the relevant products and services. In Recital 77 and 81, the key element raised is the fact that certification used by controllers and processors will be a way to demonstrate compliance. Lots of provisions following, such as in Article 24.3, 25.3, 28.5, 32.3 and 46.2f make clear that such an approved certification mechanism will be used as an element to demonstrate compliance. Another set of key provisions lay down the powers of each supervisory authority regarding certification. It shall encourage the establishment of such certification mechanisms, seals and marks, carry out a periodic review, publish criteria and conduct the accreditation. It shall review it and make it possible to withdraw certification. Finally, it will have to accredit certification bodies and to issue certifications and approve criteria of certification. The EDPB at EU level shall, on its own initiative or at the request of the Commission, encourage the establishment of data protection certification mechanisms, carry out the accreditation of certification bodies, specify requirements, and provide the Commission with an opinion on the certification requirements. When deciding whether to impose an administrative fine, adherence to an approved certification mechanism will be paid attention to in order to check on the compliance mechanisms put in place by the controllers and processors. There are no provisions in Directive 95/46 regarding approved certification mechanism seals or marks and certification body. What should accountable data controllers and processors get prepared for regarding certification bodies? First, they can use certification mechanism seals and marks for the purpose of demonstrating compliance with the regulation, bearing in mind that certification bodies will be accredited either by a national supervisory authority or by a national accreditation body. The certification body will provide the supervisory authorities with the reasons for granting or withdrawing the requested certification. On its side, EU Commission can adopt delegated acts and technical standards on certification. Such a certification shall be issued for a maximum period of 5 years and can be renewed. It does not reduce the responsibility of the controller or the processor for compliance. Controllers and processors will also have to commit to provide all information and access to their processing activities when necessary to conduct the certification procedure. The European Data Protection Board at EU level will hold a public register on certification. And finally, controllers and processors will have to pay attention to the criteria elaborated by the EDPB at an EU level, commonly identified through the name of European Data Protection Seal, and by each national supervisory authority. So the key questions still to bear in mind are: what will be the part to be played by supervisory authorities in the accreditation certification process? And will EU Commission adopt delegated acts and technical standards?